Okay, good morning, everyone. Welcome to the Committee on Veterans and Legal Affairs. We have a quorum present, so we will begin our meeting today. So obviously we're meeting virtually to take up bills that are pending before this committee. Today we have a number of work sessions on the agenda, but before we get into the schedule, we will have the committee members introduce themselves. And so we'll begin with Chairman Chiazzo.
Thank you, Mr. Speaker. Good morning, everyone. My name is Chris Chiazzo. I represent House District 28, which is the beautiful portion of West Scarborough.
Okay, Senator Farron.
Good morning. I'm Senator Farron from Urgewalk, representing Senate District 3, which is the majority of Somerset County in the town of Rome and Kennebec County.
Representative Wood.
Hi, I'm Barb Wood, and I represent House District 38, which is the western end of the peninsula in Portland.
Representative Supika.
I'm Laura Supika, and I represent District 126, a portion of Bangor.
Representative Doloff.
Thank you, Mr. Speaker. Good morning, everyone. Representative Joe Sandola from District 115 in the Western Mountains of Roxbury, Rumford, Milton Township, Woodstock, and Sumner.
Representative Riley.
Hi, I'm Representative Riley. I represent District 34, which is part of Westbrook.
Representative McCrate.
Good morning. I'm Jay McCrate, representing Harpswell, West Bath, and Northeast Brunswick in the House.
And Representative Tuttle, who's celebrating a big birthday today.
Well, Mr. Chair, as I told you, I'm counting backwards from now on, but Representative John Tuttle at District 18, the east side of Sanford. Thank you, Mr. Chair.
Yeah, well, happy birthday. And today with us, we have our committee clerk, Karen Montel, and we have both of our committee analysts, Sam Prower and Janet Stocco. Okay, and so again, the purpose of this meeting today is for the committee to receive information from staff and others in order for members of this committee to consider and vote potentially on the legislative proposals before them and make recommendations to the full legislature. Only the committee members, the committee analysts, and those specifically invited to attend will be participating in the work session using Zoom. For members of the public wishing to observe this meeting, it's being live streamed on the committee's YouTube channel and will also be recorded for viewing after this meeting is concluded. We're also broadcasting the audio of this meeting on the legislature's website. Just the usual reminders, if your video or audio is on, that means you're streaming on YouTube. And if your mic is on, people can hear conversation. So make sure that you're muted if you're not speaking. The chat function is for technical assistance only. It's not there for use for any substantive work or discussions. Members may speak with leave of the chair, and to do so, just raise your virtual hand. And again, public comment has been taken already on these bills, so now's the time for committee members to deliberate. If there's questions for people who are in the waiting room, we can bring them in, but we want to make sure that we have questions and not to reopen another public hearing. So with that, we will move to the first item on our agenda. We have LD 173, an act to restore honor to certain service members. And for this bill, we have Sam as our analyst today. So welcome, Sam. We can turn it over to you.
Thanks, Senator Lucchini. So this is my first work session with you guys at VLA, and everyone should receive the bill analysis in Janet's email this morning. Would you like me to share the screen my screen as I walk through it?
Yeah, yes? That works. Okay. Yeah, thanks.
All right, just bear with me as I make sure I do it correctly. And I'll try to do my best Janet impression, but no promises.
Can't wait.
Just kidding, I won't be impersonating Janet. All right. So as you already mentioned, this is LD 173, an act to restore honor to certain service members. I'm just going to walk through the summary and also walk through a little bit of additional information I've provided. Does that work for you?
Great.
Okay. So this bill requires the director of the Maine Bureau of Veterans Services to establish a process for veterans who separated from service without an honorable discharge due solely to the veteran's sexual orientation or gender identity, or to statements, consensual sexual conduct, or consensual acts relating to the sexual orientation or gender identity. To have that discharge treated as an honorable discharge for purposes of determining the veteran's eligibility for rights, privileges, and benefits under state law. This bill further requires the director to explore whether other states have established processes for reviewing and potentially upgrading the discharge status for state law purposes of veterans who have been diagnosed with post-traumatic stress disorder or traumatic brain injury, or who have been diagnosed with psychological trauma resulting from sexual assault or sexual harassment during military service, as described in 38 United States Code section 1720D, and who separated from service without an honorable discharge. The director is required to report no later than January 15th, 2020, back to the VLA committee on both the potential for implementing such a process in the state and the resources that would be required to implement the process. And then the committee may report out legislation to the second regular session of the 130th legislature based on the director's report. A little bit of additional information. All these links should be active for the committee. I wanted to note that a previous version of this bill, which was LD 2162, was before the VLA committee during the 129th legislature. And I believe that was the second special session. And it was reported out with a vote of ought to pass as amended. That version of the bill did not receive final action due to the shutdown. As drafted, based on my review, as far as I can tell, the bill appears to represent the same language as that committee amendment from the 129th, except the report back date has changed because we're in a different session now. And while the previous report back date was also in the month of May, the current one in this bill would be for January 15th, 2022. I've also provided some links to the State of Maine Veterans Benefits Eligibility Chart and to Macon Correctional Research Service Report, as well as links to the different parts of Maine and federal law that this bill interacts with. The reports in the benefit eligibility chart, those were materials that were also provided to the committee during the review of the previous version of this bill, so I thought they might be helpful for your review this time as well. I didn't note any particular issues that were with the bill that were raised at the public hearing. I also, in my review of the bill, didn't note any technical issues. And as far as the fiscal impact, we haven't received preliminary fiscal information at the time of me putting this bill analysis together. However, I did want to note that the fiscal note for the previous version of the bill indicated that additional costs to the Department of Defense, Veterans and Emergency Management associated with the bill could be absorbed within existing budgeted resources. There's no guarantee that will come out the same way this time, but I thought it was relevant information. I'm going to stop there. Does anyone have any questions?
Great. Thank you, Sam. Are there any questions from members of the committee? Senator Farren.
Yeah, and I think Sam and or Director Richmond, if he is on, there was some traffic floating around this weekend among the American Legion folks and some others, and I think a little bit of it was misunderstanding of this bill, and I want to make sure that I communicate and we understand that. There was some concern that this bill was going to give the Bureau direction to change a federal discharge determination. And that's not the case. That's not my understanding of this from talking with the bill sponsor as well as the previous bill that came forward. This is strictly a study to look at how that process works and what would need to be done to do that. There is no overturning of a federal determination by a specific branch of service. And that's my understanding. I guess I'm looking for some confirmation, and we're just looking for a report back from the Bureau on what they can and can't do.
Great. Thanks for that, Senator. And we just brought in Director Richmond. If you'd like to chime in on that element, or Sam, sorry.
I'll let the director go first and fill in with anything else I think might be helpful.
Good morning. Good morning, everyone. When I was being promoted from the timeout room, I missed the first part of your question, Senator Farron, but I caught the end of it. And I think the essence of it is, would anything we do at the state affect the federal document DD 214? Is that correct? Okay, no, it wouldn't. We wouldn't have any effect on their federal document. It would be a determination of would the individual be eligible for state benefits, and only those state benefits that aren't regulated by the federal government. So, for instance, the cemetery system eligibility is determined. Even though it's a state veteran cemetery, eligibility is determined at the federal level now. That's a change since last year. And the provision of a headstone that's given by the VA. So that particular benefit, we wouldn't be able to affect at the state level, even though they are state veteran cemeteries. However, state benefits that are just state benefits, we would be able to afford.
Thanks, Director. And I think that's one of the confusing parts of a lot of this is there is that interplay between federal and state benefits here. And Senator Farron, did you have a follow-up?
Yeah, and I guess the follow-up piece is also the report back piece that specifically ties to the either PTSD or TBI in the clinician piece. Can you talk about that just a little bit, Director?
Sure. My concern on last year's LD and this one too is that our bureau is not capable of making decisions that go to the clinical nature of why a member might have been discharged from military service. So PTSD, military sexual trauma, a TBI that may have, and we've seen cases, lots of cases like this, where the service member was affected by those situations, and it caused behavior that led to their discharge. But that is best determined by clinical personnel, and frankly, that's the reason the Department of Defense has boards. They're made up of a bunch of senior leaders in that branch to include clinical folks. So those are the type of decisions we would not be able to make with our current assets in our bureau. And I think our report will lead to that. But we're also, if this legislation is passed, we'll also find out what other states are doing to answer that problem. And I've talked to the director of Connecticut, and they have some type of relationship set up with their vet centers who do have clinical personnel. And they actually handled that part of the upgrade before they're only this year going through similar legislation to look at service members that got a bad paper because of their sexual orientation. So they did it the other way in Connecticut. So there's a lot to learn from other states, but that was always a concern of mine because it's outside of our capability.
Sorry, did I cut you off, Sam? Did you have anything to add, or is that?
Not much to add. I just, I think it was made clear, but I just want to reiterate that the bill essentially has like two pieces. So the first piece is there's actually it's actually directing the Bureau to create a process for at least not a change in the discharge, the official discharge status, but a change in the way Maine views the discharge status of veterans who were discharged based on sexual orientation or gender identity. And then the second part of the bill is that that directive to the Bureau to explore what other states are doing and report back in regard to veterans who have post-traumatic stress or TBI or sexual trauma. So I just want to make sure to kind of, you see those as two different pieces of the bill. And I just also wanted to note, and maybe the director can say more about this because I wasn't aware prior to this work session, but section 2 of the bill, I believe this piece about program of general amnesty does not include the process for upgrading a discharge for state law purposes under section 503 subsection 9. I believe that was to, at least my understanding after looking at the law, was to allow for veterans who had been discharged based on sexual orientation to be buried in the Maine Veterans Memorial Cemetery. So I wasn't aware of that piece of federal law change that was mentioned. And I don't think it necessarily creates a conflict on this piece of the bill, but I wondered if the director could have more to say about that.
So two issues you brought up. The first is the general amnesty, and I don't think that will have an impact on this bill. That was referring to a part of the definition of eligibility for veterans benefits based on the type of discharge. And there was a period of time when several, I don't know the number, but many veterans were granted general amnesty on their discharges. And I think that was an attempt to exclude those veterans from this legislation. But I can look into that further. The second part of your question was the veteran cemetery. Concurrently, in the last legislature, we pursued a change in eligibility so that we could align our eligibility in the veteran cemetery system with, or get it close to what the National Cemetery Administration uses. Specifically, requiring that a service member perform their or complete their term of enlistment. And that was a big change that our state law allowed for, that at the national level, they don't. So that was a fairly significant change, because up until that point, a veteran who had 1 day of active duty and received a honorable discharge for whatever reason could have been eligible under state law, but not in the eyes of the VA. And again, the VA provides the headstone and plot allowance. So we did pursue that change. So now there is a conflict, I think, for that reason. It doesn't mean that the state couldn't potentially allow a burial, but it may be against federal regulation, and it most likely would result in the headstone not being provided by the VA. So we'd have to make an allowance for that somehow. But here again, in my testimony, the first thing I mentioned that the Bureau does is pursue an upgrade at the federal level for any member that comes to us and asks for assistance. That's the first and best and lasting best thing we can do for a veteran who's in a situation like this. So hopefully, and anyone that we would look favorably upon their discharge for state benefits would be a excellent candidate to have their discharge upgraded at the federal level.
Thanks, Director. Chairman Chiazzo.
Thank you, Mr. Chair. Director Richmond, I apologize for my lack of knowledge here, but can you explain to me how that works? Does the applicant apply to the federal level through your agency, or do they apply directly?
Thanks, Representative Chiazzo. The answer is we'd put them in contact with our veteran service officer, whichever was closest to that veteran. And our veteran service officers are trained to look at the situation that particular service member's in and help them apply for an upgrade through their service branch. And if it's a difficult case that needs additional evidence, we will put them in contact with organizations like Pine Tree Legal to help build a case so that when their case is heard before the board of that service branch, they'll have a compelling argument.
Follow up, Mr. Chair?
Yep.
So in terms of the cemetery, though, so if you have a deceased, are those benefits predetermined, or would a family of the deceased apply through you to apply federally, or would they just go directly to federal, or are they predetermined based on the status of the veteran?
To answer your question, they can be either. So we encourage families who want to be buried in a state veteran cemetery to apply for eligibility before they need it, because it eases the burden on the families. However, it's not a requirement. So if they're faced with that decision and that service member's already passed, we can provide an eligibility determination locally.
So this bill, if we enact it, though, would mean that they would apply federally first. They would, in essence, be rejected because of their status, and they would have to appeal to you on the state level, or would they just apply through you for the state level, and then you would determine that, and it would be, if the federal level says no, it doesn't matter, you've already determined that they're acceptable based on this bill or this law?
I think that the first scenario would be what happened. It would be, they would apply at the federal level. They would be potentially denied based on the character of discharge. And there would be no appeal unless state legislation gives us that authority. And that would be the conflict that I'm talking about for that particular benefit.
Okay, thank you for that clarity, appreciate it.
Representative Wood.
Yes, hi. Thank you, Mr. Chair. I just wanted to say, as the sponsor of the bill, that my intent was not to get into the detail of the particular benefits, but we've all been given the chart. It's a 5-page chart of benefits that veterans who have served this country are entitled to. These benefits, some of which are at the federal level, some of these are at the state level. Whichever ones that the state controls, the purpose and intent of the bill is just that people who were discharged solely because of their sexual orientation or gender identity would be eligible for whatever those benefits are that are controlled at the state level by Director Richmond. And he can get into the detail with the individual about what those benefits are, but the intent of the bill is just to make a level playing field for the state benefits. Thank you.
Thanks. Any further discussion? Thanks, Director, for your help on that. If we're ready, is anybody ready to make a motion? Senator Farron.
I'll make a motion ought to pass.
I'll second that, Mr. Chair.
Okay, a motion of ought to pass by Senator Farron and seconded by Representative Tuttle. And I assume if a fiscal note comes, it would be ought to pass as amended. Is that right, Sam? Yeah. Okay. So any further discussion? Senator Farren.
Yeah, just one follow-up, I guess, on that, and back to the director just a little bit is, and maybe I jumped a gun with I think we do need to address his concern about the cemetery piece and the burial that Sam brought up in that one section. I think we need a little clarification on that, because I understand what Representative Wood is saying as far as that, given the director that discretion with his VSOs to have that, but we can't leave him out on an island either, especially when there's a conflict between the federal and the state piece. So I think we do need to have a little bit of language review or some direction on that piece, so the director knows exactly what it is that we're doing.
Okay, Sam, did you want to?
I didn't want to cut anybody off. Yeah, I was just looking at that piece again, and I'm not sure. Looking at the language of the law, it seems to me like all this section is doing is clarifying that members who are covered under the first section of the bill, or discharged veterans covered under the first section of the bill, are not, for state purposes, considered veterans whose status would be upgraded through a program of general amnesty. And I'm not sure that actually directs the state to do anything particular in this instance. So I'm not sure it's a change that really needs to be made. Although what I can do is we can work to clarify that after and come back to the committee if there are in fact conflict concerns. So we can always make sure to pause things before it gets reported out if there are things that need to be addressed.
Fair enough.
Right, and Senator Farren, you're good with the Sam
Absolutely.
working with Dave to try to fine tune that language?
Absolutely.
Great. Representative Chiazzo, did you have a question?
No, Director Richmond
Okay.
resolved that for me already. Thank you.
Great. Representative Wood, did you have a question? No? Okay, I got you. Okay, so seeing no further discussion, we'll proceed to a vote, and we'll take the vote by roll call. And again, the motion is ought to pass, and it was made by Senator Farren, seconded by Representative Tuttle.
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator DeChambeau. Senator DeChambeau, absent. Senator Farren.
Yes.
Senator Farren, yes. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Tuttle.
Yes.
Representative Tuttle, yes. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney. Representative Kinney, absent. Representative Harrington.
Yes.
Representative Harrington, yes. Representative Corey.
Sorry, Karen, I think technically Representative Farren, we have to see your video to count it. It's according to the rules. Sorry to do that to you.
Would you like me to go back?
If you can hear us. Yep.
You were talking to Representative Harrington, correct?
Yes. Yeah.
I think you said Senator Farren.
Oh, did I say that?
Yes.
My bad. Sorry, Representative Harrington, we're required to see people for the vote. We can't just take audio.
It's on your mind.
That's right.
Representative Harrington.
Wake up, Matthew.
Karen, we can
Come
go
back.
through the other people and then come back and see if we can.
All right. Representative Corey. Representative Corey, absent. Representative Dalla.
Yes.
Representative Dalla, yes. Representative Harrington,
Yes.
thank you. Representative Harrington, yes.
Thanks, Representative. Sorry about that. It's a rule we got to do.
So 10 yeses and 3 absent, Senator.
Okay, so the vote is 10-0, 3 absent of ought to pass as amended. So thank you, Director Richmond.
Thank you.
Good to see you, as always.
right.
Thank you, Sam,
Dave,
for your
we'll
help.
see you again, right? We'll see him again, Mr. Chair.
Plenty, yep, we'll have him in plenty more bills. So and thanks, Sam, for your work today.
Yeah, and I will follow up with Director Richmond and let you know the results of that conversation. If and I'll bring it back whenever I get the fiscal information or before if that seems urgent. So.
Great, thanks a lot, Sam. Okay, so I think that concludes the first bill.
Mr. Chair, sorry, there's a question from Representative Wood.
Yes, Representative
Mr.
Wood.
Chair, I think when you said the vote count, you said ought to pass as amended. And I just was confused.
It's a fiscal note.
The vote will either be ought to pass, or if there's a fiscal note, it will be ought to pass as amended, with the amendment being the fiscal note. Yep.
Okay, so we do that in advance before. I just didn't know that's how it worked.
Yeah, it's just saying if there's a fiscal note attached to it, that it will amend the bill to attach that fiscal note.
Okay, thank you.
Yep.
And you'll get a chance to see that before
Right.
the bill goes out. We bring those back. So.
Okay, so we've got 3 more bills on the agenda, but I think what we may do, if co-chairman and Senator Farron are good, we'll take a quick 15-minute caucus break. That sounds good. We will take a break and then come back and try to be 11 or a few minutes after.
Well, Mr. Chair, I may need the help of a good chairman, House Chair, to help me with the caucus.
Yep.
He can give me a call and straighten me out if that's possible.
Yep, we'll do it.
Better.
I'll send one out in like a couple minutes. So.
All right, you're in the will.
The call is certainly possible. I don't know if I can straighten you out, Representative Tuttle, but I'm happy to try.
Well, Chris, you're in the will. There's nothing in the will, but you're in it.
Okay, so we'll come back about 11:05-ish. So thanks. And the same link will work when we return.
All right, I'm gonna call, I don't think I can, I mean, I'll look, but I don't think I'll probably call IT or.
Hey, Karen, we're good now. If you can hear me, we're able to get in. Okay, we'll just give people a couple minutes to come back in. It was locked for a minute there, so give people minutes and a couple minutes just to start up, and then we'll get back into it.
Senator Lucchini, I know Representative Kenny is trying to get in. I know Karen's working with her.
Okay, thank you. Yep,
Mr. Chair, if you change my name again,
gotcha.
thank you.
That'll be 3 Lukinis on the committee now.
So, Senator, are we all set right now?
Yeah, it's stopped locking. Yeah, it's unlocked. I think Janet was able to unlock it.
Okay, good, thank you.
For some reason, yeah, it did a lock.
Okay.
So, but
Chris,
we'll give people a couple minutes.
Chris, if he keeps getting all Senator Lucchini's on here, there'll be no divided reports from this committee.
Senator Farron, there are no divided reports as it is now.
Okay, I think we have enough to get at least a vote if we need to. Obviously, anybody not here can register their vote after. So this, so we'll reconvene, and sorry for the delay. We had a little technical thing. We're going to this afternoon. We have 3 bills scheduled for work session. LD 306, enact to temporarily waive certain requirements for relicensing for restaurants. LD 307, enact to expand the market for main liquor manufacturers. LD 378, enact to temporarily waive renewal fees for online or for on-premises retail liquor licenses. And after that, we'll do a couple of language reviews, I think. And then in the afternoon, we do have a public hearing as well. So with that, we'll start with LD 306, and we can turn it over to Janet.
Hopefully you see my screen.
Yep.
Okay, LD 306, as the senator said, is an act to temporarily waive certain requirements for relicensing for restaurants that serve liquor. So under current law, several categories of retailers licensed to sell liquor for on-premises consumption are required to sell a specified amount of food as a condition of licensure. So for hotels, with a small exception for certain hotels that have a license that doesn't require the sale of food, but most hotels, restaurants, and bowling centers have a requirement under statute that at least 10% of the gross annual income be from the sale of food. The statute also notes that a bowling center's income from the bowling business is not considered as part of this calculation. So it's really a sort of a food versus liquor ratio. There's also statutory requirement for Class A restaurants and lounges, and qualified catering services. And they have to sell a specific dollar amount of food each year, depending on the size of the municipality in which the establishment is located and the number of months the entity is open. So there's a chart that's attached to this analysis, the last couple of pages, that shows you in detail what exactly those dollar amounts are. But as far as the bill, it's an emergency measure that would temporarily exempt all of these categories of licenses from the statutory requirements for food by providing that as long as the license expires on or before January 1st, 2022, the licensee is not required to demonstrate that it satisfied this food sales requirement that's in statute. So the Bureau alluded to this in its testimony, and just to understand, although the statute, oh, I'm echoing, is that better? Okay. Although the statutes in Title 28A aren't drafted in an entirely consistent manner, current law does authorize and sometimes require the Bureau to deny a license renewal application if the licensee has a food sales requirement and they're unable to demonstrate compliance with that requirement. So the restaurant licensing statute, the Class A restaurant lounge statute, and qualified catering establishment statutes all specifically state that the Bureau may not renew any license for the sale of wine or malt liquor or spirits, if that category applies to the licensee, unless the licensee furnishes proof to the Bureau that the previous year's business conformed to the income requirement of this subsection. So that would be the food income requirement. So those statutes are very clear. The Bureau doesn't have any discretion. It can't renew the license if the food sales requirement isn't met. There isn't similar language in the statutes governing hotels and bowling centers, however, but there is a general statute governing approval of licenses, and that includes license renewals, and it provides that a license may be denied on one or more of the following grounds, and one of those grounds includes a violation of any provision of this title. So under that statute, even though the hotel and bowling center statutes don't specifically say the Bureau has to deny the license, they do have the authority to deny the license if the food sales requirement wasn't met. It may be helpful or not, I don't know, to know that in the 129th legislature, there was this large bill that's been alluded to several times before this session. It was LD 2131, an act to correct errors, inconsistencies, and conflicts in and to revise the state's liquor laws. And that bill had several provisions involving these food sales requirements. I'm not going to go through all of them, but just so that you know, on the one hand, that bill would have added language to the statutes governing hotels and bowling centers to clarify that the Bureau can't renew those licenses unless the food sales requirements were met. So that's the two licenses that don't have that language very clear right now. That bill also would have established a 1-year grace period for any on-premises licensee that fails to demonstrate compliance with a statutory food sales requirement when it applies for license renewal. So under the bill 2131 and the 129th, if you couldn't demonstrate your compliance, you were allowed to have a renewal for 1 year. It was a permissive, so the Bureau had that option. And after that, you would have to prove compliance or your license couldn't be renewed anymore. That bill was unanimously reported out of the committee with an amendment that didn't affect those provisions, but it ultimately died because of the pandemic. It never reached the floor. So as far as this bill is concerned, the Bureau proposes amending the bill, which right now just waives the food sales requirements for a year. And they suggest replacing that with a 1-year grace period that's similar to what was proposed in 2131 and the 129th. So under that Bureau proposal, if the on-premises retailer is required by law to sell a specific amount of food and it can't demonstrate compliance, the Bureau may renew the license for 1 year. I don't think it's significantly different, but I did put the Bureau's language that it proposes on the right and the language that came from LD 2131 in the past on the left, just so you can compare. They're both 1-year grace periods. They just get there by using slightly different language. And you can direct me to pick one, or I can look at both and kind of massage them so that they all look the same, but it's basically a 1-year waiver. The only technical issue I wanted to raise was that if you don't switch to a 1-year waiver as proposed by the Bureau, and you instead say that for 1 year, the food sales requirements are waived, the bill as drafted says that it applies to anyone whose license expires on or before January 1st, 2022. So since these on-premises licenses are all 1 year in duration, if your license expired between January 1st of this year and whatever date this bill takes effect, then you've sort of lost your opportunity to have this waiver, which may be fine with all of you, but I just wanted to point that out. You may want to instead rewrite that to make it sure it covers everyone for the whole year if you decide not to go with the grace period instead. Hopefully I haven't confused you with that. So here's the chart about the different entities that are required to sell food. It looks like hopefully what I posted before the public hearing, except that I did clarify that the income from the bowling business isn't included when you calculate whether a bowling center met its requirement.
Thank you, Janet, for that. That's really helpful chart as well. Any questions from Janet or from the analysis for Janet? I think from my perspective, why I submitted this in working with President Jackson's constituent is simply that the pandemic has just completely changed business models for restaurants, and we want to make sure that they can't have their license rejected because their numbers don't hit the marks that we usually require. I prefer the waiver method over the grace period. I think if we if we gave them a grace period and then if they violated that, then all of a sudden they could have their license rejected the next year. And to be honest, all of our restaurants are still operating under very difficult situations by the executive orders that mandate capacity restrictions and things like that. So my preference, and obviously whatever the committee thinks, would be to go with the waiver method. And I think going back to January 1st makes sense. Representative Tuttle.
Thank you, Mr. Chair. Would it be appropriate to make a motion ought to pass as amended with the waiver language? Would that be the correct motion, Mr. Chair?
Yes. Yeah. And does your motion include going back to January 1, 2021?
Yes.
Great. Great, thanks. So motion of ought to pass as amended. Is there a second?
Second.
I couldn't tell. Oh,
It was me.
Okay.
It's a holdover from my council days.
The boxes just keep moving all the time. So, okay, so seconded by Representative Supika, the motion by Representative Tuttle. And again, the motion is to use a waiver and to have it retroactive to 2021. Chairman Chiazzo.
Thank you, Mr. Chair. I was just going to comment before the motion that I would concur with the waiver. It sounds like it's cleaner and more easily applicable than the grace period, easier to manage. So, but Representative Tuttle beat me to the punch with the motion, so I will support the motion and the amendment.
Well, Chris, I'll have to correct that in the future.
He was quick out of the gates.
He's very quick. No, sir, you're keeping me on my toes. I appreciate that.
Okay, Representative Kinney.
Thank you, Mr. Chair. I'm trying to remember which bill is which. I've had so much internet problems this morning. I'm just glad I'm finally online. Does this one, if we go with January 1st, 2021, does this require the Bureau to issue refunds to anyone? Okay, Janet's shaking her head no, so this is not that one, so I'm good.
Right. Yeah, this would be if they're in process currently, they couldn't be rejected if they didn't hit the numbers. Yep. The other one's coming up will be the fees.
The only thing I'm unsure of, just to respond to that, I don't know if they have rejected anybody already. They'd have to go back and grant it, sort of take away the rejection, but that's not a refund. So.
Okay. Great. Any further questions or discussion on this one? Seeing none, we'll proceed to a vote. We'll take the vote by roll call. And again, the motion is ought to pass as amended, with the amendment being the bill plus going retroactive to January 1, 2021.
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator DeChambeau. Senator DeChambeau, absent. Senator Farren.
Yes.
Senator Farren, yes. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Tuttle.
Yes.
Representative Tuttle, yes. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
Yes.
Representative Kinney, yes. Representative Harrington.
Yes.
Representative Harrington, yes. Representative Corey. Representative Corey, absent. Representative Dalla.
Yes.
Representative Dalla, yes. 11 having voted yes and 2 absent, Senator.
Great. Thank you, Karen. Okay, so that's 11-0 unanimous of those present, and anyone absent can call or email in or call their vote by noon the second day. Okay, so next up, we'll move down to LD 378. Since it's fairly similar to that last one, LD 378 is an act to temporarily waive renewal fees for on-premises retail liquor licenses. And we'll turn it over to Janet.
Okay, sorry I'm so pale in this screen right now. I'm not sick. It's just a weird video connection.
It is very faded.
I feel like a ghost. I don't know how to fix that. Sorry. So LD 378, as the senator said, is an act to temporarily waive renewal fees for on-premises retail liquor licenses. It's another emergency measure, and it does what the bill's title says. So during calendar year 2021, the license renewal fees would be waived under the bill if you're an on-premises retailer. This is the bill, Representative Kinney, that would involve refunds as currently drafted. So the chart that's attached to the bill sets forth the annual fees applicable to on-premises retail licensees. During the public hearing, the Bureau proposed amending the bill with respect to the timing of the fee waiver. So rather than waiving the license renewal fees for on-premises retailers during calendar year 2021, which would require Bablo to issue refunds for any fees paid between the beginning of the year and the effective date of this emergency legislation, the Bureau proposes amending the bill to provide for waiver of license renewal fees for 1 year, beginning on a specific date after the effective date of the bill. The Bureau also proposes an amendment involving extensions of the licenses. So because on-premises liquor licensees were prohibited from providing dine-in service between March 18th and June 16th of 2020, as a result of the governor's executive orders during the coronavirus state of emergency, the Bureau reports that it's been working with on-premises retailers to extend the expiration date of their licenses. So the Bureau suggests amending this bill to provide in law for a one-time 90-day extension of the expiration date for all on-premises liquor licenses. And when I say one time, that would be 90 days added to this year. Now your renewal date is moved by 90 days, so it'd still be yearly after that. It wouldn't be like you'd lose some time in the future. The New England Convenience Store and Energy Marketers Association requested that the bill's 1-year waiver of license renewal fees be extended to establishments licensed to sell liquor for off-premises consumption. I typed all this up and had it all ready to be posted, and then I realized I never told you what those fees were. So there is a separate chart. It's posted online on the committee page, so you can look at the on-premises liquor license fees if you want to see what the bill covers right now. If you want to see the off-premises liquor license fees, this is what the proposal is to amend the bill to include those fees as well. Just in case you want to know the sort of potential fiscal impact of that, the on-premises fees are also attached to the bill analysis. So I didn't have any technical issues to raise with this because the Bureau already raised them. And although we don't have the fiscal note prepared or a preliminary fiscal note from the fiscal office, as this is a fee waiver, there will certainly be a fiscal impact.
Thank you, Janet. Any questions for Janet on the analysis? Again, I think this one I put in with Greg Dougal from the Restaurant Association, just as we all know they've struggled significantly, and this would be some sort of financial relief to them. And of course, if it does pass, then we have the other hurdle of the appropriations table, which is always a difficult hurdle to go with. Yeah, so any thoughts or discussion in terms of Senator Farron?
Yeah, thank you, Senator Key. So on this, right, obviously we know what we're facing with some of the budget discussions that's coming up. If we pass this with a fiscal note, at least put it onto the table, at least, and correct me if I'm wrong on this, we'll have an avenue or a bill that we could always pick up and amend, because there are certain groups, you know, we've focused on restaurants and some of the premises stuff, but there are the Class A lounges that have not been able to open at all in over a year. And I just think that this gives the committee a vehicle that we can kind of monitor how it all plays out going forward. Just my thoughts on that.
Thanks, Senator. Yeah, and I agree. Those people who have been really hard hit are the lounges, and you know, certainly we don't want to charge them. Chairman Chiazzo.
Thank you, Mr. Chair. Yeah, no, I agree with Senator Farron. I think this is a great mechanism. You know, it helps that particular sector of the community that's been struggling through the pandemic, and gives us a little flexibility to react down the line later too if we need it. So I'm definitely in support of the measure.
Great, and I think one of the questions would be whether the timing, I guess, of the fee waiver if we wanted to do, as Representative Kinney pointed out, the refunds potentially going back to a certain date. I don't know how the committee feels on that. If there's any thoughts.
Well, is there a date recommended, Senator?
I'm good with whatever the committee decides. You know, we've had licenses being renewed kind of nonstop during this entire time. Some people have paid, and I think the Bureau has given they've been very good working with some to just give them extensions of time. And while I appreciate the 90-day extension, I don't think that does enough to cover, because they're still operating under some pretty significant hardships. Representative Kinney.
Thank you, Mr. Chair. I guess my thought is, if they've already paid for their license for this year, where we are facing such a budget shortfall, to turn around and send a refund, that's going to be even more costly than just refunding or waiving the fee. As I'd rather see this maybe go so that everyone has the opportunity to have 1 year, a one-time fee. If we pass this one-time waiver of the fee, so that if they've already renewed, they'll get their next one waived. And I don't know how we would put that into language, but that would be how I would prefer to see this happen, rather than issue refunds.
Right, and Janet can hopefully clarify that for us.
Sure. Representative Corey had asked a similar type of question on a completely different bill about tying effective dates to different events, and it's very possible to draft this in a way that it is tied to the effective date of this legislation. So it could be from the effective date, whatever that date is, for exactly 1 year period. We could do that.
Okay, and so just to maybe clarify, so it'd be effective date for 1 year, so that should cover everybody. And would we want to, I guess, include that they were operating during 2020, just so that, so it's a waiver, not like a brand new license.
Yes, Mr. Chair.
I don't know what people think on that. So
The way it's currently drafted, it's for renewals. So
okay, yeah, I think renewals covers it. Representative Chiazzo.
Thank you, Mr. Chair. I'm sorry, I need a little clarity on that point. So are you saying that we, depending on whatever date we say becomes effective, 365 days of waiver? Is that correct?
Yeah, my understanding. So I think it would be whenever the law becomes effective. So I guess if it has an emergency, it'd be, after the governor signs it, it'd be for 1 full year. So that would cover everybody for renewals during that one previous calendar year.
Okay, I just wanted to clarify that. Thank you.
Sure. Any other questions? Okay, is anybody ready to make a motion? Senator Farron?
Just, I guess, as a sponsor, Senator Lucchini, what's your thoughts, on the waiver piece as opposed to the refund piece?
I think I like the recommendation Representative Kinney made, so that we won't be going backdated to refunds, but for a full calendar year, we're going to just waive fees for those who are on their renewals. So they'll get a free one at some point. But if they paid 6 months ago, then we'll get them the next time around.
Perfect. With that understanding, I'd make a motion to pass.
Okay. And as amended with those?
As amended.
Okay.
Second, Mr. Chair.
Okay, so we have a motion of ought to pass as amended by Senator Farron and a second by Representative Tuttle. And Janet, are you good on the amendment, amended language? Great, so any further discussion? Seeing none, the motion before us is ought to pass as amended. We'll proceed to a vote, and the vote will be taken by a roll call, and we can do it in just a second when Karen's ready.
Sorry, that was Representative Corey.
No, no problem. You get a lot of phone calls during these meetings, so we know you're super busy.
Behind the scenes. Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator DeChambeau. Senator DeChambeau, absent. Senator Farren.
Yes.
Senator Farren, yes. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Tuttle.
Yes.
Representative Tuttle, yes. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
Yes.
Representative Kinney, yes. Representative Harrington.
Yes.
Representative Harrington, yes. Representative Corey. Representative Corey, absent. Representative Dolph.
Yes.
Representative Dolph, yes. Eleven voting in favor of the motion with 2 absent, Senator.
Great. Thank you, Karen. So it's a unanimous of those present, 11-0 and 2 absent, and they'll have until noon on the second day to cast their vote. Okay, so next up on the list, we can move over to LD 307, an act to expand the market for Maine liquor manufacturers. We can give Janet and Karen a minute to finish up the vote tallies, and then we can move on to those.
Hey, Senator, while we're waiting for that, can I make a comment?
Absolutely.
While we're doing all these Bablo rules and refunds and everything else in these challenging times, I know that we got Mr. Sanborn and Director Minio and Tim Pullen and some others on here. Is that I received a call yesterday from the American Legion Post in Madison that I belong to, and they just wanted to let me know about how great the Bureau was to work with through these challenging times, and that they really helped the Madison. And I just wanted to publicly recognize the folks for doing that, and I appreciate those calls. We don't, as legislators, we always get those calls all the time. So just want to say thank you to the staff that's doing some good work out there.
Yeah, we don't always get the happy calls, but yeah, no, I've heard the same that the Bureau's done great to be flexible with all of these licensees, but you know, these larger steps they can't just do on their own. So,
exactly.
But yeah, no, they've been very accommodative to the industry, so it's been appreciated by my constituents as well.
I'm ready if you are.
All set.
So LD 307 is an act to expand the market for Maine liquor manufacturers. It's another emergency bill. This bill provides that it's not a violation of Maine law for a licensed Maine liquor manufacturer. That would include a distillery, small distillery, rectifier, brewery, small brewery, winery, small winery, or bottler. So it's not a violation of Maine law for one of those Maine liquor manufacturers to sell and ship its products directly to consumers located in other states, as long as the licensed Maine manufacturer complies with the laws of the state in which the customer is located and receives the liquor. Just because this came up sort of tangentially, and it's not something we've talked about before, this session, I wanted to give you a slight bit of background on the state power to regulate importation and sale of liquor. So Section 2 of the 21st Amendment to the U.S. Constitution grants each state the authority to control the importation and use of alcohol into its borders. So the text actually states the transportation or importation into any state, territory, or possession of the United States for delivery or use therein of intoxicating liquors in violation of the laws thereof is hereby prohibited. So that's what the 21st Amendment states. So one might theoretically interpret that language as granting each state unlimited authority to restrict the importation into the the state of liquor. I don't know why there's so many typos today. I think I was tired. The U.S. Supreme Court has held that the 21st Amendment does not authorize states to enact liquor laws that violate other provisions of the Constitution. So this is broad authority, but there are some restrictions. An example given in a case from 2019 was that a state couldn't prohibit importing liquor for sale to individuals of certain races. That would violate the Equal Protection Clause of the 14th Amendment. So there is broad authority to states, but it's not unrestricted authority. As another example, more relevant here, in Granholm versus Heald in 2005, the U.S. Supreme Court held that while states may enact laws regulating the importation of sale of liquor in order to protect the public health, in doing so, they may not favor in-state entities and discriminate against out-of-state entities in violation of the so-called Dormant Commerce Clause of the U.S. Constitution. So what Granholm specifically stated was that states have broad power to regulate liquor under Section 2 of the 21st Amendment. This power, however, does not allow states to ban or severely limit the direct shipment of out-of-state wine if they're simultaneously authorizing the direct shipment by in-state producers. If a state chooses to allow direct shipment of wine, it must do so on even-handed terms. So if you hear people talking about the Granholm case, it stands for the proposition that if you open your market up specifically to in-state entities, you have to even-handedly open it up to out-of-state entities unless you can come up with a justification for why those should be treated differently, and usually the state loses any such attempt to come up with a justification. Another helpful quote is from Tennessee Wine and Spirits, which was a more recent case. And in that case, the Supreme Court said the 21st Amendment allows each state leeway to enact the measures that its citizens believe are appropriate to address the public health and safety effects of alcohol use and to serve other legitimate interests. But it does not license the states to adopt protectionist measures with no demonstrable connection to those interests. So under current law, to understand the background of this, a licensed main winery or small winery, as well as an out-of-state winery with a federal wine manufacturing permit, may obtain a direct shipper license to sell and ship its own wine products directly to a customer located in Maine. And I've hyperlinked the statute there. It's 1403-A. There's no provision of Maine law authorizing the direct shipment of spirits or malt liquor to Maine customers, however. Instead, under the statute governing Maine manufacturers, that statute only explicitly authorizes a Maine manufacturer to sell its products to customers for off-premises consumption at the premises of its manufacturing facility, or for small wineries and small distilleries, they can obtain a license to sell their products for off-premises consumption at up to 2 additional locations beyond the manufacturing facility. But none of those provisions say you can sell it somewhere else that's not your facility, like through the mail. There's also permission for manufacturers that are breweries or small breweries to sell growlers at their on-premises licensed locations. Obviously, a growler is going to be consumed off the premises, though. So those are the specific places in Maine law that it allows a Maine manufacturer to sell its products for off-premises consumption, other than this direct shipper permit. So there's no existing way for a Maine manufacturer to ship spirits or malt liquor through the mail directly to a Maine customer. As far as out-of-state manufacturers, there is a specific statute in Maine saying that the sale by mail order of liquor from an out-of-state company directly to a Maine customer is expressly prohibited, the only exception being if you get this direct shipper license for wine and you're a winery. So it's important to know, because this came up and there seemed to be a little confusion at the hearing, that this bill does not alter these provisions of Maine law or in any way authorize any additional direct-to-customer sales and shipments of liquor to customers who are located in Maine. Instead, the bill provides only that a Maine manufacturer may take advantage of another state's law permitting direct-to-customer sales of liquor to customers located in those states. So there is no enhanced shipment directly to a Maine customer. Instead, it just says if another state, for example, New Hampshire, allows you to ship products directly to its customers, we're not going to stop you just because you're a licensed Maine manufacturer. New Hampshire might stop you if you don't follow their laws, but Maine won't. So as far as the direct to customer liquor sales for customers in other states, so these are the states that allow some direct shipments, and these are the states where the bill would say Maine manufacturers go ahead and ship there, just make sure you follow those state laws. So each state that does allow direct shipping has a slightly different approach. And I just gave some examples because it's very difficult to find every single state law because every state writes them very differently. So these are just some examples so you know how it works in other states. So some states, for example, Alabama, prohibit the direct shipment of all liquor to consumers. So you can't order by mail in Alabama. So if this bill passed, Maine liquor manufacturers can't sell to Alabama because it's not allowed. Delaware has a provision which seems to allow direct shipment to customers, but it actually doesn't, because if you're a out-of-state manufacturer or retailer, you have to actually ship it to a wholesaler who then delivers it to a retail licensee who then delivers it to the customer, which is a very interesting system. Mississippi does something similarly where if you're out of state, you have to deliver it to the package store, which is the retailer, and the customer has to go pick it up. So you can sort of direct order it, but not entirely really. Many states like our own state of Maine and Massachusetts, our neighbor a little bit to the south, they authorize direct shipment of wine, but not other liquor to customers by licensed in-state or out-of-state wineries, as long as those wineries obtain an additional direct shipping license or permit. And that, just to remind you, is the Granholm case. Maine and Massachusetts could not choose to just allow in-state wineries to ship to their customers. If they allow in-state wineries to do so, the Granholm case says they have to allow out-of-state wineries to do so as well. Other states, for example, Vermont, will allow the direct shipment of wine or malt liquor to customers by either in-state or out-of-state manufacturers, as long as they obtain that direct shipping license or permit. So if this bill were enacted, Maine manufacturers could ship to Vermont as well, wine or malt liquor. They just have to get that Vermont license or permit. There are a few states, Kentucky and New Hampshire are two that I was able to confirm, that authorize the direct shipment of all kinds, spirits, wine, and malt liquor by in-state or out-of-state licensed manufacturers. And indeed, as I read the New Hampshire law, it would even allow out-of-state retailers to make those shipments. Again, they have to obtain the direct shipper license. So if this bill were to pass, LD 307, a Maine manufacturer would be able to ship spirits, wine, or malt liquor to Kentucky or New Hampshire, as long as it produces those products and it obtained that additional license from the state where the shipment is being sent. There was a question raised at the public hearing whether this would affect sales to Canada. As drafted currently, the bill only addresses sales to consumers in another state. There is a lot of information you can find online about what the requirements are for exporting liquor to Canada. This is from the federal TTB, and they give a lot of information about what permits you need to ship to Canada, et cetera, and so forth. I didn't see anything in Maine law saying that if you're a Maine manufacturer, you can't ship to Canada. I think it's similar to what this bill recognizes, which is it's really up to the recipient country, or in the bill, the recipient state, to make the rules about how things are imported to that location. There was, during the hearing, a potential Commerce Clause issue raised. So at least one individual who testified expressed concern that challenges may be brought to the bill under the dormant Commerce Clause of the US Constitution. I did speak with the Attorney General's office about this issue. And they agreed that somebody might try and bring a case. That could always happen. They did think that this bill, if you chose to enact it, would be defensible, however, because if you remember in this Granholm case that I talked about, what the US Supreme Court said was, if you open your own market as a state to in-state manufacturers to direct ship to customers, then you also have to open your own market in your state to out-of-state manufacturers. You can't discriminate against the out-of-state entities. Nothing in this bill opens up the market to Maine customers any differently than the market already exists, however. And there's nothing about this bill that says in-state entities have a higher or a broader way of getting their products to Maine customers than out-of-state entities too. So nothing about this bill treats out-of-state entities differently as far as accessing the Maine market. What really is happening here is that it's up to the other states to decide. So under this bill, recognizing, for example, that New Hampshire allows shipments into its state, this bill says, well, if you're a Maine manufacturer, go ahead, follow New Hampshire law, send your products directly to customers in New Hampshire. We don't have any control whether New Hampshire allows those direct shipments. That's entirely up to New Hampshire. So for those reasons, at a minimum, and at a first blush, when they were given very, very little time to review this bill, the Attorney General's office thought they could at least defend this bill if you decided to pass it against any potential Commerce Clause challenge. So there's no guarantee one would be brought, but they thought it was a pretty defensible law if it was brought. There was a proposed amendment from the Maine Grocers and Food Producers Association. So they proposed amending the bill to a resolve that would establish a study involving representatives of different stakeholder groups to assess consumer demand for these direct-to-consumer sales, any opportunities for meeting that demand, and whether to include licensed Maine retailers in making direct-to-consumer sales. So their testimony seemed to focus on sales to Maine customers, which really is not what the bill is about, but perhaps they're suggesting sort of changing the focus of the bill. They did note in their testimony that they believe that under current law, there are unauthorized direct-to-consumer sales going on, and they expressed concern about that. So as far as issues raised by the Bureau, the first issue it raised was reporting requirements and consistency with 1403A. So the Bureau noted that the bill does not require either reporting or tracking of direct shipments of liquor that would be made by Maine licensed manufacturers directly to customers located in other states. By contrast, they noted that 1403-A, which if you remember is the direct shipper of wine statute in Maine, it provides that a licensed Maine winery that has a direct shipper license, and that license would allow it to ship its products directly to customers in Maine. But even though that license only allows shipments directly to customers in Maine, there is a provision of that statute that does require the winery to file an annual report with the Bureau that includes both the total number of cases of wine shipped to recipients in the state and shipments made outside the state. So even though the direct shipper license that we have right now only involves sales to Maine customers, if you're a Maine winery and you get that license, you do have to report to the Bureau any direct shipments you make to customers in another state. So they suggested if this bill were enacted 307, you might want to also require reports from every Maine manufacturer that makes any shipments out of the state. As far as taxes, the Bureau noted in its written testimony that it's unclear under the bill as drafted what types of taxes apply to sales of liquor by licensed Maine manufacturers directly to customers in other states. So we know what taxes apply if you go to the store and buy liquor now in Maine, but the question is what happens if these direct shipments are made out of the state? So further speaking with the Bureau and a little bit with the Attorney General's office, and further research has revealed some information about the sales tax. So resale sales of liquor for off-premises consumption that take place in this state are subject to the 5.5% sales tax that generally applies to personal property. That quote in this state might suggest that the question whether liquor sold by a Maine manufacturer and shipped directly to a customer in another state, whether that's subject to Maine sales tax, might depend on whether we decide as a legal matter that the sale took place in Maine or not in Maine. But that's sort of a red herring, and that was where I think the Bureau was originally looking at the language when it made its testimony. If you remember, Director Minio did then say, oh, wait, I think that sales tax isn't going to be a problem. And I think he's right, because it was pointed out to me that there is an exemption from the sales tax under 1760-82. And it says that there's no sales tax or use tax on any sale of tangible personal property, that includes liquor, when the seller delivers the property to a location outside of the state using the USPS or a common carrier. It doesn't matter whether the sale is considered to have taken place in Maine or not. Sales tax won't apply because it's exempt under 1760 sub 82. So then the other tax question is the excise tax. So under section 1652 of the liquor laws, there's an excise tax applicable to malt liquor and wine. Unfortunately, the wording of this statute is somewhat difficult to decipher. So although subsection 1 of that statute says that an excise tax is imposed on the privilege of manufacturing and selling malt liquor in the state, which suggests that the tax is imposed on all malt liquor manufactured in Maine, regardless of where it's sold, the final sentence of that provision that should say subsection 1, it states that the Maine manufacturer or importing wholesale licensee shall pay an excise tax on all malt liquor sold in the state. So that sold in the state language suggests only malt liquor that is considered to have been sold in Maine is subject to the excise tax. So, okay, that would mean these shipments out of state to a customer located in another state, maybe they're not covered by the malt liquor excise tax. Confusingly, however, every other subsection of 1652 that governs the excise tax on low alcohol spirits, fortified wine, sparkling wine, hard cider, and all other wine, those subsections don't have that sold in the state language. They instead merely state that the excise tax is imposed on the privilege of manufacturing and selling these products in Maine. So if you manufacture in Maine, it sounds like the excise tax is imposed. Speaking with the Bureau, it's explained that it's resolved this ambiguity in the language by looking at a different subsection of 1652, which is the excise tax for malt liquor and wine. And that subsection 2A, states that every brewery and winery must pay excise taxes on malt liquor and wine that the brewery or winery removed from areas required to be bonded by the federal government. So what does that mean? It means that each Maine manufacturer has to report all malt liquor or wine products that it removes from its manufacturing facility, that's the bonded area, on the excise tax forms it submits to the Bureau, regardless of where the products are ultimately sold. So under 2A, you report all that, excise taxes are due. The Bureau then indicated to me that it adjusts the amount of excise tax due by giving Maine manufacturers a credit for all wine or malt liquor that it sells to an out-of-state wholesaler for resale out of the state. But it doesn't believe that that credit would be due, the Bureau doesn't believe, if the Maine manufacturer sells malt liquor or wine directly to a customer outside of the state. But they're dealing with what is admittedly a confusing statute. That's what their interpretation is at the moment. I'm sure they will correct me if I'm wrong. But the upshot of all of this is that the Bureau suggests clarifying in the bill whether excise taxes should be paid by a licensed Maine manufacturer of malt liquor or wine if it engages in direct-to-customer sales to customers located outside of the state. So instead of leaving it to a parsing of this language and trying to figure out exactly where their sale take place, it might make sense for the committee to just clarify that provision and whether it applies to these direct-to-consumer sales in another state if you want to move forward with this proposal. As far as spirits go, they have a completely different excise tax. You may remember a little bit about this from our presentation on taxes earlier in the session. So the state spirits tax or consumer's tax on spirits is established in 1651. And if you remember, that tax amount is sufficient to pay all spirits related expenses of the Bureau, to fund the Liquor Operation Revenue Fund and the Maine Municipal Bond Bank, and to cover the premium tax, which is used to fund substance use disorder prevention and treatment services. Under that statute, this tax amount is incorporated into the retail price of spirits products established by the State Liquor and Lottery Commission. However, there are certain categories of spirit sales that are not subject to this tax. So it says that taxes on spirits imposed by the state do not apply to the sale of spirits by manufacturers holding a license issued by the Bureau if the sale is made to any instrumentality of the United States, to a vessel of foreign registry, to an industrial establishment for use as an ingredient in the manufacture of food products, or for use as an ingredient in the manufacture of commodities that can't be used for beverage purposes. So generally speaking, the excise tax on spirits is incorporated into the retail price, but that retail price incorporating the tax isn't going to apply if it's sold to one of these entities or for one of these purposes. There is a separate statute in Title 28A that specifically allows the Bureau to set the price. Presumably that would be a price that's different than the retail price because it's not going to include this tax, at which agency liquor stores can sell spirits to government instrumentalities or to airlines and ferry services for liquor that's not going to be for consumption within the state. So in its testimony, the Bureau expressed concern that it's unclear whether this tax on spirits applies to the sale of spirits by a Maine manufacturer directly to a customer in another state. It suggested that this question might depend on whether the sale is considered to have taken place in Maine. So again, just like with the malt liquor and wine excise tax, the Bureau suggested clarifying in this bill whether you want that excise tax to apply. I would note that the way the excise tax is written, it's all incorporated into the retail price. If you can imagine selling a spirits product, if you're a Maine distillery, right now, if you sell it to a Maine customer, you have to use the Maine retail price. That's the law. If you were to sell it to a customer in New Hampshire, I don't know what control New Hampshire has over that retail price. But if we tried to impose our retail price and thereby impose our excise tax, and then New Hampshire tried to impose its retail price and it was somehow set differently, that could be a problem. The last concern the Bureau raised was staffing. It expressed a concern that allowing direct-to-consumer shipping in other states by Maine manufacturers is a significant change in Maine law, which would require the Bureau to oversee these new types of sales by as many as 24 Maine distilleries, 12 Maine large breweries, and 134 small breweries. Note that it didn't anticipate any increased oversight or staffing expenses by allowing Maine wineries and small wineries to make direct-to-consumer sales in other states, because these manufacturers already have the ability to make such sales to Maine customers, and they're already reporting their sales to other states under 1403A. I would note, however, that this staffing concern really depends on whether Maine imposes excise tax or reporting requirements, because those are the types of things that the Bureau would be overseeing. Just as a technical issue, regardless of how you actually decide, the issue of whether Maine excise taxes should apply to these sales to consumers in other states, it might be helpful to just clarify this excise tax law, either in this bill or a future bill, because I mentioned it's a little bit confusing. There is no fiscal impact statement yet, but as the Bureau testified, it might need additional staff to oversee these sales depending on the types of requirements you impose. So that's something to keep in mind.
Thank you, Janet. I think this bill, obviously there's some tax stuff that we'll likely have to clear up, as was recommended by Bablo, and I think it makes sense to do it because there's a lot of internal conflicts. Representative Tuttle.
Yeah, Mr. Chair, I would agree with you. The taxation issue is one that's been around a long time, and I think if we want to proceed with this, we have to clarify that. I just don't want to do something that is going to allow folks to ship out of state, putting those in state at a competitive disadvantage. So I think we really need to look at the excise, the sales, and sort of do something consistently. So it might be wise to table this and get that information, Mr. Chair.
Yeah, I think I think it's good. We can have people ask questions that they need, and then we can, if people want, eventually table this and then pick it up at another time. And again, just as the sponsor, just to clarify what this does and doesn't do, this does not open Maine up to be able to receive out of state direct to Mainers through the mail. That's a much bigger bill that's coming later this session by Senator Stewart. This, as Janet kind of described in her analysis, would allow our main businesses to sell to the states who have opened up that direct to consumer for their people. So states like, I think Vermont, sounded like Kentucky, New Hampshire, they've said that their citizens can buy from out-of-state manufacturers. And so, as we've talked about, this would give our manufacturers the opportunity to expand their customer base into other states. And by not opening the state of Maine, we aren't giving a preferential treatment to anybody. We're simply trying to get our businesses more customers. And I think that's why when we talked to the Attorney General, they felt this was defensible to do it in this manner, because really you can't sell into another state unless they approve you to do so. So are there other questions? Perhaps we can bring in people for questions. We'll bring in Director Mineo as well as Anya Trundy from DAFS. Because I think, as was explained in testimonies, clarifying this excise tax issue will be what needs to happen. And I think the practice within the industry is that if you export as a direct to consumer, the receiving state pays the excise tax, but our laws are not clear on that. So that's something that we would have to clarify. So Representative Wood.
Thank you, Mr. Chair. I just wanted to make a comment, actually 2 comments, I guess, is it does absolutely seem like the excise tax needs clarification. I did just want to mention on the sales tax, some of you are probably tired of hearing me talk about LL Bean, but I worked there for 30 years, and I just want to say that on an LL Bean shipment to a customer, if it's shipped in Maine, then sales tax is collected. But if it's shipped outside of Maine, there's no sales tax for the state of Maine. So that piece of question about sales tax, I think is pretty clear and is already in practice in many other businesses outside of the liquor business, how sales tax is handled or not handled in this case.
Right. And Representative Wood, I think you're exactly right, because if the transaction takes place out of state, then we don't collect sales tax. And then this exemption in Title 36, 1762, sub 82, I think is actually kind of nicknamed the LL Bean exemption. So you get the exemption anyway. So it was an interesting conversation we had with the tax people on that exact point.
In fact, LL Bean's first venture. Yes.
Sorry, I don't know if it's me or Representative Wood, but I couldn't quite hear.
I know I'm freezing.
Okay.
No, I'm done.
Come back
Thank
to you.
you.
Yep. Representative Chiazzo, did you have a question or?
No, I'm good. Thank you, Mr.
Okay, so I guess since we have Director Mineo and Anya up here, just to clarify the excise tax. So on current practice, if a Maine manufacturer, so that's a Maine brewery, distillery, or winery, sells to an out-of-state distributor, the practice by Bablo is to charge them excise tax and then to credit it back to their account. Is that correct?
They pay the excise tax on total production, and then they're credited back for something that would not be applicable, such as selling to a wholesaler. That's correct.
So you charge excise tax for the product that's sold out to an out-of-state distributor, and then you credit it back.
They report gallonage and pay the excise tax on everything that they produce, and then they're credited back on something that's not applicable. I don't mean to be, I'm just saying that's one example, Senator. There are others, such as selling to military installations and things like that.
I fully understand there's others, but yes, you credit back all sales to out-of-state manufacturers.
All sales to out-of-state wholesalers.
Let me clarify that. Yeah.
Wholesalers.
You credit back all sales to an out-of-state wholesaler.
Correct.
Okay. Anya, did you have a question or a comment on that?
I just wanted to clarify, I think we're talking about a transaction that is taking place on paper, but where money is not exchanged. But it's a subtraction modification on the form.
Correct. It's an accounting exercise. That's exactly right.
Right.
So they owe, as a starting point, they owe, there's a tax obligation on all product manufactured, but then there's a subtraction modification, like a deduction, for anything that is shipped out of state.
Correct.
Great. Thank you, Anya. And
yeah.
So the net effect, Anya, is that you don't pay excise tax on sales from a main manufacturer to an out-of-state
wholesaler.
Correct.
Anya,
yeah.
okay, let's go, Director, let's go one at a time. We're gonna ask Anya. So Anya, go ahead.
Yeah, yes, correct. The bottom line would be that you would be paying the tax liability on the product that remained in the state of Maine for sales.
Great, that's helpful. And Director, did you want to add?
No. I'm sorry. I didn't mean to interrupt. I just said the word wholesaler. I apologize.
Yeah, it's just hard when two at once.
No, my bad.
Representative, and just to follow up with one further question. So Maine allows direct to consumer shipping of wine. So our Maine-based wineries, so when a Maine-based winery sells to an out-of-state wholesaler, they effectively do not pay an excise tax. But when a Maine-based winery sells to an out-of-state consumer, the practice is that they pay excise tax.
You asking me?
Yeah. Yep.
Yes.
And can you explain the rationale for that?
It's the way it's stated in statute right now, that they pay everything, and that is not considered an exception. And it may be a little blurry in law, but the way we look at it is that that's the way it's been done. I will say that amount of business is de minimis, doesn't make a difference, but it is, by the way. There's only 9 in-state wineries that have a direct shipper license out of 40 or 50, I think we have.
Right, but under the same exemption that you give the sale to an out-of-state wholesaler, there's nothing preventing the Bureau from giving that same exemption to an out-of-state customer. It just simply, I believe you're referencing the
1403,
or the excise tax exemptions are the credits given under 1652. Is that correct?
Yes, and also we'd have to tie it back into 1403. Those two sections of law overlap in this type of situation.
Right, but 1403 has nothing in there that requires excise tax payment on the outward bound shipment. It only specifies inwards from out-of-state manufacturers.
Yes, but we'd have to go back and look at it. We've reread it ourselves 3 times since the public hearing, and we would ask for clarity there. It has been our practice to not have that to be an exemption, if you will, on excise tax.
Right, and yeah, I think as you all pointed out, it would be helpful to kind of clean up a lot of that because it's filled with internal inconsistencies.
Yes, sir.
Like
Absolutely.
Much of today. So
Absolutely.
Hopefully we can attempt that. Chairman Chiazzo.
Thank you, Mr. Chair. I think this is probably for Ms. Trundy. So I think we do tax internet transact or internet commerce. So if this was going to be a direct to consumer out of state through an online portal or something, I would assume would it still be subject to sales tax, not the excise tax? Just talking sales tax.
Yes, we collect sales tax on internet transactions that are sourced to Maine, and the sourcing is based upon the shipping address to which they're delivered. So if the shipping address, like Representative Wood was talking about earlier with the LL Bean example, is an address in Maine, then we collect a Maine sales tax on it. But anything outbound, the sales tax would be collected by the receiving state. And I think likely that same principle would extend to excise tax.
Okay, thank you for that clarity.
Great, thanks. Representative Corey.
Thank you, Mr. Chair. So after listening to the analysts report back to us and, realizing this is heavily steeped in tax issues, was this bill misreferenced to come to us? It seems to be, a much larger tax bill than a VLA bill. I know we're deciding what to do with alcohol here, but, at the end of the day, this is heavily steeped in tax and, a little bit less steeped in policy. So I'm not sure why we're dealing with this bill in this committee.
I'd say that, as written, the bill didn't really implicate excise tax things, but what we found is the inconsistencies in the title have kind of brought them to the forefront. But I will also add, the excise tax policy is in 28A, and we typically deal with that for alcohol. We don't typically deal with sales taxes though, but the excise tax on alcohol we usually deal with, where it's not in the tax statute, but it's in 28A. Representative Tuttle.
Mr. Chair, would it be appropriate to make a tabling motion now, or would you like to wait?
Well, if nobody else has any further questions, then we can. Just wanted to give people a chance to clarify anything so they can bring it back for next time. So seeing none, Representative Tuttle?
Well, I move that we would table this, Mr. Chair. You mentioned that there is another bigger bill coming from Senator Stewart.
Representative Tuttle, if you're making a motion to table, we can't have discussion. So it's going to be.
Okay, you're right. I used to do that to you, Louis, when you were a freshman like I am. But anyway, I would move that be tabled, Mr. Chair.
A motion to table. Is there a second? I heard it somewhere. I don't know where. Okay, seconded by Representative Chiazzo. For this one, we'll just do a show of hands because I think we've got everybody on camera. All those in favor of tabling, please signify and hold up your hands and I'll read it off. So we have Representatives Tuttle, Riley, Dolph, Supika, Wood, Kinney, McCrate, Chiazzo, Patrick, Harrington, Senator Farren, Senator Lucchini. Anyone opposed? 0? Okay, so unanimous. Those present, so it's tabled and we will bring it back at a future time. Thanks to Director Minio and thanks to Anya for your help. And I can try to work with Janet and with you both to try to clarify some of the excise tax language, and then we can see if we can bring something acceptable back to the committee.
Sounds good.
Thank you. So Janet, next we have 2 language reviews, I believe, right? That we can take up while we have time. I believe we have a language review on LD.
Do you care which is first?
Let's go LD 16. I think Director Champion's been waiting around for a while.
Sure. Sorry, I have to open it up. 1 sec.
Yep.
These I don't post ahead of time because they're confidential until I show them to you in public. So. Okay, LD 16 was an act to change the renewal application deadline from 6 months to 60 days before the expiration of a license issued by the Gambling Control Board. This is a unanimous ought to pass as amended report. If you remember what the original bill did, is it said that generally right now under current law, you have to apply for renewal of your Gambling Control Board license 6 months ahead of time. And this would change that to 60 days ahead of the time that your license is going to expire. But during the work session, you discussed the fact that for casino operators and slot machine operators, they have to get municipal approval prior to renewal of their license. And there's provisions in that municipal approval law that suggest it could take about 60 days for that to happen. So if there was only 60 days prior to renewal of your license when you had to apply, it might sort of become a problem. So this amendment that you directed me to draft, and you directed me to work with Director Champion, and I did, and he's seen this language because you gave me permission to work with him. It says here in section 1 and section 2, it talks about the slot machine operators going to get municipal approval. And it says they have to do that at least 60 days before they file their renewal application with the board to make sure that there's not going to be an overlap in time. So they're going to have a 60-day period when they get the approval from the municipality, and then another 60-day period to file their renewal application with the board. Section 3 and section 4 do the exact same thing as sections 1 and 2, except that it applies to the casino operator renewal process. They just happen to be in 2 different statutes, so you have to amend both of those statutes to get the same effect. The other thing that this does here in this middle sort of unnumbered paragraph is it amends the part of the bill that says you have to apply with the Bureau 60 days before expiration of your license. And it just restates, before you do that, if you're a casino operator or a slot machine operator, you have to go take care of that municipal renewal process first to make sure everything's clear about what the order of the steps are. The only other thing that this amendment does is it clarifies in a different provision of the law, which says, because remember, this is about license renewals. Well, there's another provision of current law that says all licenses issued by the board are effective for 1 year, but that's not actually true because advanced deposit wagering licenses are effective for 5 years. So it just clarifies that by eliminating that inconsistency or conflict in the law. It just says, nope, it's actually the advanced deposit wagering aren't 1 year licenses. This 1012A is just adding the cross-reference because this says that this provision of the renewal statute says the board's allowed to renew casino operator and slot machine operator licenses if they go and get their local approval, but it forgot and it only cross-referenced one of those statutes. So this adds the cross-reference to both. So it looks like a lot of stuff, but all it's doing is cleaning up sort of technical little things with the law to make sure it all works together with the bill.
All right, thank you, Janet. Any questions from the committee for Janet on the language review? All right, I don't think there's any action required. I think it's just review. So Senator Lucchini's back. I will turn it back to him.
Thank you, Mr. Chair, and thanks, Janet. And thank you, Director Champion, for waiting, but looks good. Okay, next up, we have a language review on LD 205. And if we want, before we get into that one, I've had further conversations with Mr. Dougal from the Hospitality Maine and the restaurants on this bill, and if they would be willing to make some changes to try to get a unanimous report, because obviously we divided on third-party delivery, which the restaurants had asked for, but can probably live without to a certain extent. So if we'd like to reconsider, we would just need a motion from the prevailing side to reconsider, if anybody's willing to make that motion. Representative Chiazzo.
Thank you, Mr. Chair. I will move for reconsideration.
Okay, so motion to reconsider on LD 205 by Representative Chiazzo. Is there a second?
Second, Mr. Chair.
Thank you, Representative Tuttle. Is there any further discussion on the motion to reconsider? Seeing none, we'll proceed to a vote. And I think if people are good, we'll just do a show of hands on this. All those in favor of reconsidering, please raise your hand and I can read it out and just hold them up so that people listening can hear. So it's Representatives Chiazzo, Riley, Kinney, Dolph, Tuttle, Harrington, Senator Farren, Rep Wood, Rep Patrick, Corey, Rep McCrate, and Senator Lucchini. Thanks. So unanimous of those present. You got your names switched around again, Representative Corey.
You know what, though? It's only in this one, so I wonder if it's how they send out the invite.
That is interesting, yeah.
With my name like that, because in AFA, it doesn't do that. And then when I have regular meetings, it doesn't do that either. So I don't know if it's the invite or what does it.
Well, Patrick, they just want to aggravate you.
It never seems to keep the names. Okay, so I think the language that divided the committee, as far as I can tell, was the provision about third-party delivery. And maybe Janet, can you put up the majority report where that is in, and then we can work up, if people are good, a change to that.
Sure. So this is the draft of the amendment. Ordinarily, just want to explain to the newer folks, ordinarily when I do language review, I try and wait until the bill looks exactly the way that it'll look like when it's reported out to the floor. But this was one where the motion was made and there was some confusion about how exactly it would be drafted. And you all gave me permission to work with Senator Lucchini to make sure that it's drafted the right way. So I wanted to bring it back to you and make sure, independent of this reconsideration, I wanted to make sure it actually did what you wanted it to do and you were okay with it before I sent it to the revisor's office. So anything red is a difference from the bill, the way it's drafted, and anything highlighted would be a difference between the majority and the minority report. So the highlighting is the stuff about third-party delivery that you would be getting rid of here if you go ahead and vote that way. So the first two sections, these are provisions of Title 28A that involve license suspensions and revocations and the imposition of fines. This is another area, unfortunately, I feel like I'm beating a dead horse. This is another area of the law where Title 28A is internally inconsistent. So a section, which is Section 801 of the law right now, says the court has jurisdiction over violations of this title by licensees and their agents and employees. And an agent would be somebody like a third-party delivery. But then Sections 802 doesn't restate the part about a licensee's agent being something that could be cause for revocation or suspension of a license or imposition of fines. So the first two provisions of this bill, to make sure it's crystal clear that if there's an agent involved, for example, a third-party delivery company, it's to make it crystal clear that the licensee, their own license, could be on the hook for any violations of law by that agent. So that's what these two provisions do. The rest of this bill is the rest of this amendment really looks very similar to the way the bill is drafted, and it just has some changes. I don't know if you just want me to talk about the agent provisions, Senator Lucchini, or all of it. I can just go through and show people.
Yeah, I think especially anywhere that the two reports may have differed, just so we understand where the differences were. Is that red? I can't remember.
Yellow is where the two reports would be different.
Oh,
but just to let you know what the red is, I'll try and be really quick. You all, the motions, both sides, majority and minority, wanted to allow approved cocktails to include wine. So that's why there's some red text about wine here in the approved cocktail definition. You also wanted to make sure that if the approved cocktail was made by somebody between 17 and 20 years old, who's the employee of the licensee, they had to be supervised. So that's what the red text is there. There was a long discussion about the type of container that an approved cocktail has to be in. And Senator Lucchini read some language to everybody that was incorporated in both majority and minority reports. And this is how I rewrote that language to look like Maine statute. So it has to be rigid. It can't be paper or polystyrene. It can't have any openings or anything like that to be a container for a to-go cocktail. You also agreed in both reports to, instead of having rulemaking about what's going to be on the label, to just put right in statute that it's going to have the name and license number of the entity that sold it, as well as the date it was prepared and sealed, and it has to list the ingredients. So all that would now be right in the statute. There'd be no rulemaking. Something that both reports also included was to try and be clear about both who can make these sales if they're an on-premises retailer and what food has to accompany these sales. This definition right here is the reason I thought we needed a preliminary language review. So the way that the Bureau had proposed amending the bill was to say, if you're an on-premises retailer and you're required by law to sell food, then you could sell all of these to-go drinks as long as it was accompanied by a food order. And the food order would be the type of food you're required by law to sell. But speaking a little bit more and investigating this a little bit more, if you remember, the statutes in Title 28A, as we talked about earlier today, are very specific about the amount of food certain licensees have to sell, but not necessarily the type of food that has to be sold. So the Bureau has issued its memorandums that allow for these sales to go under the governor's executive orders. And this is the specific type of food that's listed here. This is the specific type of food that the Bureau is currently requiring to be sold with an order of beer, wine, or spirits to go as an improved cocktail. So in order to keep consistent with what's going on currently, Senator Lucchini suggested just being very clear in the amendment that this is what the food order is. It's a hot or cold meal. It could be like a sandwich or a hot dog or a pizza, but it wouldn't be just like a bag of chips. So that's what that definition is. That's not precisely how it was talked about at the work session. However, that's why I wanted to bring it back and make sure you were okay with going with the current rules that the Bureau is applying to these to-go sales.
Right, and that was kind of the goal of this, was to bring it into, because I know food order was an issue that came up a lot, and we wanted to make sure that we were clear that it actually does come with food. And I think from talking with the restaurants, they're good with that. And it makes sense to give it some clarity and not go through rules, because that would take a long time for the Bureau to go through that, since this is a 1-year extension.
Right, and so the other thing that's important to say is any on-premises retailer, whether they have a food requirement in law or not currently, any on-premises retailer would be able to engage in these sales of alcohol to go, but they do have to provide an accompanying food order that meets this definition. So if they don't have the kitchen facilities or the ability to sell food, they're not going to be able to do it. But it's not going to be by virtue of which license category they have. It's by virtue of whether they can, in fact, accompany the to-go or the go sale with a food order as defined here. The other thing, the bill as written defined qualified on-premises retailer to include distilleries, and I think it sort of confused people the way it was written. So I just broke them out so you can tell which are the things that retailers have to do and which are the things distilleries have to do under the bill. I thought it was a little clearer that way, so I'm proposing that change. That's not from Senator Lucchini, that's from me.
You're way better at drafting than I am, Janet, so good idea.
I drafted both versions though, so if you don't like either version, that's on me.
You draft multiple versions just in case? I'm not surprised.
Okay, so this paragraph B, I'm just pointing out that if you're an on-premises retailer, under the amendment, you have to have it accompanied by a food order. That's to clarify because the distilleries aren't included there. They don't normally sell food, and everybody had agreed at the work session that they wouldn't be required to all of a sudden sell food here. All of this paragraph C language is in the bill, but it's in one big block paragraph. Now it's broken out. It's just saying if you're an on-premises retailer for wine, you're going to be able to sell wine to go. If you're an on-premises retailer for spirits, you can sell cocktails to go, but you can't sell something you're not allowed to sell in your premises, off of your premises. The only other change here, the reason there's red text, is you all had agreed that the sales of wine don't have to be just wine in an original container. It could be wine mixed in an approved cocktail. And then, so that's what this says. You can sell wine as an ingredient in an approved cocktail, but if you're on-premises retailer and you only have a license to sell wine, you can't start mixing cocktails that include spirits because you're not allowed to sell spirits. So that's what this says. If you can sell wine and spirits, you can mix them together. That's basically what it says. Again, you had wanted to clarify that a distillery, when they sell their approved cocktails, those cocktails can contain their own spirits. That was allowed under the bill. And they can also include mixtures that have spirits produced by somebody else or wine, because little did I know, vermouth, which I thought was a spirit, is actually a wine, and you need it for certain martinis or Manhattans. I don't remember which. That shows my ignorance, but that's what this was all about. The Manhattans or the martinis. And you said that if you are a distillery and you mix somebody else's spirits or wine with it, you have to purchase that ingredient from a reselling agent because you don't make it yourself.
Yeah, and that was a Bablo recommendation, and that totally makes sense to me. And does that also cover the, I'm sure you're probably going to get to it, that they can't sell that product later? It's only the stuff they make for the distillers? Sorry.
Well, they're not authorized anywhere to sell that product.
Right. Gotcha.
And it says they can only sell it as the ingredient of the cocktail. And the cocktail can contain these things, but it doesn't say you can sell the bottle of wine on the side.
Perfect.
The paragraph F is the part about deliveries, and this is where there is a slight difference between the majority and the minority report. And that's about the agent here. But just to explain what this does is it would clarify that if you're selling liquor for off-premises consumption, whether you're a retailer or a distillery, you have to deliver it to the customer. And who can deliver it? Under the majority report, it would be the actual retailer or distillery, or an employee or an agent of that retailer or distillery. So an agent would be something like a third-party delivery service. No matter what report you're on, and even under the bill is drafted, you can only deliver it if you're at least 21 years of age. You can't deliver to a visibly intoxicated person. And then this paragraph, subparagraph 3, would be in both reports. Just in the minority, you wouldn't have an agent. But what this does is what you asked to do, which to require the person making the delivery to verify by means of photo ID that contains the person's name and date of birth, that the person to whom the delivery is being made is not a minor. And then the last change was to change the date upon which this bill would sunset to September of next year rather than April as in the bill. So basically all of these agents and this clarifying language about the liability of licensees for things by their agents is the stuff that would make it very clear that third-party delivery is allowed under this bill. I think that's what you all talked about, maybe reconsidering.
Thank you, Janet, for that. Yeah, and just walking through with the restaurants, just in the spirit of trying to get something done, because it's very important. They're willing to not do all the clarifying stuff around the third-party agent, but just leave it as Bablo currently kind of does it. Representative Tuttle.
Yes, Mr. Chair. I know that Representative Kinney had some concerns with the original draft, but I didn't know if we could recognize her to see how she feels about the changes.
Yes, for sure. Representative Kinney.
Thank you, Mr. Chair. Sure. My concern was around the third party delivery, and I'm still open to trying to find a way to make that work, but I think it needs more consideration than what we've given so far. Excuse me. Sorry, it's cold down at Sugar House. Making my nose run. Coughing does not feel very good right now. It hurts a little bit.
Okay.
Sort of laughing, but so I guess if we were willing to pull that out for right now and maybe look at this as maybe something else, as the delivery piece, as something different, maybe it can be incorporated in some of these other bills we're working with the direct to consumer, that maybe we can come up with something that would make me feel a little more comfortable. But the way we're looking at doing this now, I'm pretty comfortable with just eliminating that third party piece, but allowing the restaurants to do the delivery themselves would be fine with me.
Great, and thank you. Yeah, I think as if we take out that third party piece as we had written it, where you couldn't, because we did have issues with liability, but just I think what I would recommend is just keeping it as Babel's doing it currently, and yeah, not trying to do the liability stuff around that, because that did raise some issues too. Chairman Chiazzo.
Thank you, Mr. Chair. If it helps, I will make a motion that we ought to pass as amended by removing references to the third party delivery and accepting the language as presented by Janet, if that helps form the basis of the discussion.
Second, Mr. Chair.
Okay, we've got a motion of ought to pass as amended by Representative Chiazzo and seconded by Representative Tuttle. And I think this is one that we can, where this is a preliminary language review, we can bring it back and take a look again once it's drafted and run it by others as well. That way we don't go too far outside of what's currently done, and we don't restrict what's currently done. So any other questions or discussion on this? Seeing none, we'll proceed to a vote, and we'll do the vote by roll call. And just a reminder, the motions ought to pass as amended.
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator DeChambeau. Senator DeChambeau, absent. Senator Farren.
Yes.
Senator Farren, yes. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Tuttle.
Yes.
Representative Tuttle, yes. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
Yes.
Representative Kinney, yes. Representative Harrington.
Yes.
Representative Harrington, yes. Representative Corey.
Yes.
Representative Corey, yes. Representative Dollop.
Yes.
Representative Dollop, yes. 12 in the for the motion and 1 absent.
Mr. Chair, you're on mute.
Yeah, I realize it. It sends a thing when it says you're muted when I'm trying to talk to the blank computer. Yeah, so thanks everybody. Thank you, Karen. And I think the restaurants will be happy to give them that relief, and hopefully we can get that ready for when we have session. So I think that's it for the language reviews. Did we have a public hearing at 1 today? I feel like I can't see the calendar, but
Yes.
okay, we've got a bill coming up at 1 o'clock, so we'll just take a 10-minute break just to let everybody grab a drink or food or whatever, and then we can come back at 1 and we'll bring up the bill, which I don't have in front of me, but we'll do our hearing at 1 o'clock. Great, so we'll see everybody then. Thanks. Okay, so we'll get started in a few minutes once we get some more members here. We do have our bill sponsor, it looks like. So we'll bring up the representative in a minute once we get more members here to restart the meeting. So. Okay, we'll bring the committee back from our recess, and we'll move on to the afternoon part of the agenda. And this afternoon we have a public hearing on LD 413, an act to apply the same auditing standards to all candidates and political action committees. And again, just very briefly for those members of the public who are here who wish to testify, just reminders that this meeting is being live streamed on the committee's YouTube channel. So if your mic's on and your camera's on, people will be seeing you. We're also live streaming this through the State House audio channel. And for anybody who's signed up to register, signed up and registered to testify, we'll bring you up to the meeting. It may look for a second like you're being dropped, but then you'll come back in. So don't shut off the computer. You may go blank for a minute, but then we'll bring you to the meeting. So again, we just ask members of the public to state your name, your place of residence, and the organization you represent, if any. And we use a 3-minute clock. So if you can tailor your remarks to 3 minutes, that would be great. And if committee members have questions, just raise your virtual hand and we'll get those questions asked. So with that, we'll open the public hearing on LD 413, an act to apply the same auditing standards to all candidates and political action committees. And we'll recognize the sponsor, Representative Reisman. Welcome.
Thank you, Mr. Chairman, and good afternoon, Senator Lucchini and Representative Caiazzo and other distinguished members of the Committee on Veterans and Legal Affairs. I am Representative Walter Reisman from Harrison, and I represent District 69. I'm testifying today in support of LD 413, an act to apply the same auditing standards to all candidates and political action committees. Most likely, we can agree that on the state level, we have spent more on political campaigning this past election than in any other cycle in Maine history. Let's look at something startling about the statistics about our last election. $95 million is spent on the U.S. Senate race, $12,800,000 on the 2020 state legislative races. There are 1,060,000 registered voters here in the state of Maine, and that means we spent $101 for each voter. Seems like a lot of money. The point is, regardless of the money spent on political campaigns, the state's voter participation rate remains fairly stable at 76%. That's third in the nation. That's good work, Maine. We've done a great job getting out the vote. Now the questions are, how does that money get raised and how does it get expended? Well, first of all, let's look at contributions. Political contributions come from 3 sources: private government money, such as the clean election funds, or political action committee funds. Private sources and government funds are subjected to important laws and rules that provide oversight to ensure compliance to acceptable campaign standards. PAC money is allowed to be a little bit less transparent as to the origination of funds. In 2020, it was reported by followthemoney.org that $3,612,000 came from public subsidy funds like clean elections, while $4,995,000, close to $5 million, came from party-related sources, i.e. either state leadership PACs or specially funded PAC money. On the other side, the expenditure of campaign funds. Campaign finance laws and rules are in place to protect right to know and prevent corruption or the appearance of corruption in political campaigns. Current disclosure requirements for government-funded campaigns are at the forefront of providing reasonable standards and rules that ensure that campaign expenditures are lawful, accurate, and timely. The public has a reasonable expectation that reporting will be accurate, thorough, and timely. Setting a standard for audits will clearly convey to all campaigns and PACs the importance of careful bookkeeping, proper documentation retention, and the best practices of campaign reporting. The current system has two pieces, a compliance review and an audit process, both administered by the Maine Ethics Commission. A compliance review is conducted for all candidates, but not necessarily all PACs. The compliance review is simply a check that finance reporting is complete. On the other hand, an audit is more comprehensive and an in-depth analysis of financial transactions by selecting a sample of activity to ensure the expenditures are campaign-related and follow the MEC expenditure guidelines. Under the current statute, this only includes clean elections candidates, and only 20% of them are randomly audited. Audits work. Auditing between 2012 and 2016 showed an increasing level of compliance with the rules. The most common examples of significant deficiencies include not reporting unpaid debts, incorrect vendors specified on a form, or not keeping satisfactory documentation. A review of the past history of the compliance and audit processes for clean election candidates provide a track record of providing accountability in our elections. It has done the job in furthering the integrity of the election process. I believe it's time to expand the effort to bring further improvements to the process by expanding this activity to all candidates and PACs. In the 129th legislature, a bill very similar to this was considered and approved by the legislature. Unfortunately, it excluded PACs. Regardless, however, it did die on the appropriations table when the legislature concluded its business in November. It should be noted that it contained a fiscal note that assumed all candidates and PACs would be subjected to a random audit. Under the provisions of this new bill, it grants rulemaking authority to the Elections Commission to consider the auditing levels. It's quite possible that in rulemaking, the Commission could lower the threshold from 20% random audits for clean election candidates to a 10% level of random audits for all candidates and PACs, and that being at a reasonable level of cost. The importance of providing expanded oversight to all candidates and PACs for audits is emphasized by earlier testimony showing the increased expense levels and the potential exposure to intended or unintended violations of the election process. We have a duty to ensure the public that we are committed to increasing accountability, transparency, and integrity to our election process. I encourage the committee to vote unanimously and ought to pass for this bill. I'm available to answer your questions. Thank you for your time.
Thank you, Representative Reisman, for your testimony. Any questions from the committee at this time? Representative Corey.
Thank you, Mr. Chair. So I've been through the audit process and the Maine clean election thing, and I came out clean, and I was I was fine. I did all my bookkeeping and everything else correctly. But you had stated that that auditing has led to more compliance, but I don't know how we can be sure of that. Has anybody studied that it's actually the auditing that's led to more compliance, or is that people better understand the rules now and sort of everything else? So I'm not against auditing. I just don't know that, you know, you can make that inference based on auditing. Thank you.
Yes, thank you for that question, Representative. That statement I made on that came directly from previous testimony of the Maine Ethics Commission, and it was based on what they saw as a trend between the years 2016 and 2020.
So just to follow up, so that's their inference, but there wasn't a study or anything else that shows that's the case?
I could find out more information
Thank you.
on that for you if that is something you'd like to know more about.
Great. Any other questions for the bill sponsor? Seeing none, thank you, Representative Reisman.
Thank you.
So next we'll move to the people who signed up to testify today. So first on our list, we have Bob Howe from Maine Citizens for Clean Elections. So we'll bring up Bob, and then after that, we'll have Director Wayne from the Ethics Commission. So we'll bring them both up, but we'll start with Bob Howe.
Okay.
There you are.
Got to push all the right buttons. I'm
Yeah.
not sitting in front of my maple sap house today. That's an 1837 painting, I think was the year of the Maine State House.
Great.
Thank you for this opportunity, Senator Lucchini, Representative Caiazzo, and members of the VLA committee. I'm Robert Howe. I'm a resident of Brunswick, where the SAP has started to run. I'm here today as the registered lobbyist of Maine Citizens for Clean Elections, testifying in support of LD 413. Maine Citizens for Clean Elections has been the leading campaign finance organization in Maine for over 20 years and one of the nation's most respected state-based organizations advocating for democratically funded elections. We are proud of our national reputation, but we are all Mainers, and our nonpartisan mission has always been with and for the people of the state. We believe the requirement to randomly audit both candidate campaigns and political action committees will raise the level of compliance and strengthen public confidence in our campaign finance laws. And we thank Representative Reisman for bringing the bill forward. It's appropriate to audit both privately funded candidates and clean election candidates alike. LD 413 is fair in its requirement to audit equal percentages of each type of campaign. Clean election and privately funded candidates are subject to important laws and rules that provide transparency and eliminate opportunities for corruption and its appearance. Political action committees are vehicles for massive amounts of money in politics. In all cases, the public has the right to know who has donated to campaigns, who is paid by campaigns, and how funds are spent. Because disclosure requirements are the foundation that allow for enforcement, the public has a reasonable expectation that reporting will be accurate, thorough, and timely. Setting a standard for audits will clearly convey to all campaigns and PACs the importance of careful bookkeeping, proper document retention, and other best practices of campaign reporting. Audits will help us see how well we're doing when it comes to routine compliance with campaign finance laws. They may verify that campaigns are compliant with all aspects of the law. They may expose sloppy bookkeeping and poor record keeping, or reveal actual violations of the law and rules. The results of the audits may suggest improvements to our disclosure laws and the rules that govern reporting. In short, random audits will strengthen accountability and increase compliance. We encourage a vote to pass LD 413. And thank you very much.
Thank you, Mr. Howe. Any questions? Representative Kinney.
Thank you, Mr. Chair. I just brief, real quick. You may not be in front of your SAP house, but I'm in mine. I will agree. The sap is flowing. And wouldn't you just agree that this is a beautiful day to have the sap flowing?
Yeah, and here I am inside. That's a gorgeous sap house. Mine is much more primitive.
Any other questions? All right, seeing none. Thank you, Mr. Howe. Great. So next on our list is Director Wayne from the Ethics Commission. Welcome, Director.
Good afternoon, Senator Lucchini and Representative Chiazzo and other distinguished members of the committee. I'm Jonathan Wayne, the Executive Director of the State Ethics Commission. And first of all, I wanted to commend the sponsor on his attention to all of this. And I wish everyone had as much of an interest in how political campaigns are financed in general and our state, our office's oversight of them. I'm afraid I'm in the situation today of explaining how we go about audits and what some of our staffing and cost constraints are, and sort of offering reasons why it would be a challenge to do what the sponsor is proposing, but I'm in no way adversarial to what the sponsor is trying to do. And if he has any questions or wants to talk to me directly, I'm really eager to do that. So we are a small independent agency in Maine state government. We only have 6 employees. We do not have anyone with an auditing or an accounting background. So we are required to audit candidates for governor that receive Maine Clean Election Act funding, and that's only natural because they receive hundreds of thousands of dollars of public funds. And in our discretion, we also audit 20% of the Maine Clean Election Act candidates. And the reason that we do that is that, I think we paid out, $3.5 or $3.8 million to the legislative candidates every 2 years. And some of that money does come back to us. I think the net amount that we paid out to legislative candidates in 2020 was $3.5 million. And that's an awful lot of public funds to pay to sort of mom and pop campaigns for the legislature. So in order to reassure the legislature and taxpayers that there's a minimum of waste and fraud and abuse in this program, we undertook voluntarily to audit the legislative candidates. And I think it does, just to answer Representative Corey's question, it's really hard to make the causal connection. We like to think that if Maine Clean Election Act candidates know that they could be audited, they will pay more attention to their financial reporting and make sure that their reports are accurate, and that they keep all the required records in case they are audited. We think there's a benefit there. On the other hand, we tend to think that the Maine Clean Election Act candidates and, importantly, the traditionally financed candidates, both very much pay a lot of attention to reporting. So we haven't seen the kind of widespread reporting errors by the traditionally financed candidates that have really compelled us to do a systematic audit. The last thing I wanted to mention, because my time is limited, is our budget situation. Auditing traditional candidates would have to be done by the general fund. This is something that's important for you to know independently of this bill. I may go into it in our budget presentation next week, but we only have approximately $9,000 for administrative expenses. And that really precludes us from hiring outside auditors. And I welcome another opportunity to go into that with you because it affects all of our operations in terms of how little general fund money we have to spend. So thank you very much.
Great. Thank you, Director. And is there a request for more funds in the biennial budget?
So there is not. And the reason that there isn't is because of the virus situation. Some of you may remember last year in the 2020 session, we finally screwed up our courage and said to the legislature, we need more general fund money to realign our personnel costs and to be able to adequately pay for administrative costs. That actually was part of a supplemental budget bill that was before the legislature last year in 2020, excuse me. And it actually did get the support of this committee, I think, but because the legislature adjourned due to the virus, it sort of fell through the cracks in 2020. We did not propose it as part of the biennial budget bill, just because our budget deadline was August of last year. Things were atrocious due to the virus. I knew there'd be a shortage this year. I just didn't want to burden the legislature with it. We are in contact with the executive branch. We are hoping the finance commissioner will see fit at a future time, either as part of a change package offered later this year, or maybe next year as part of a supplemental budget bill to fix the situation. But basically, we will be asking for more general fund money because we're overcharging the Maine Clean Election Fund for personnel expenses as well as administrative expenses. And we'd love to make our e-filing system as good for everyone involved who has to file a financial report with us and for the public to get the information. But we really are limited by our general fund situation. So thank you for the question. And hopefully there's more to come on that at some point.
Great. Thank you, Director. Representative Corey.
Thank you, Mr. Chair. I've got a couple of really quick questions. Are violations ever found without audits?
Oh, absolutely. We have people people can file complaints if they think that the opposition's campaign finance reports are incomplete, if they see financial activity going out there by their opposition that they don't see reflected in reports. People under Section 1003, they can file complaints, and then if the commissioners think good cause has been shown, we'll do an investigation, and those frequently do result in findings of violation. Also, yeah, well, I'll just stop there. Yes, that's correct.
And that would include, just real quick, PACs, non-traditional candidate or traditional candidates, and clean election candidates, correct?
That's correct.
Like all three of those.
Yeah.
Cool. So you had mentioned the new e-filing system. When you first put this out there, like I got it and I'm like, oh my God, another thing for me to learn, right? But I grew to love it. In a lot of ways, it's saved me from having to write things out and give them to my treasurer, and it's gotten better and better. Have you seen better compliance with individuals since you've adopted that sort of easy to use e-filing system?
Well, it's, we have noticed, I think most candidates really want to do things the right way. Most people, they just don't quite understand what's required of them. And I think that's the biggest factor. I appreciate you saying that the e-filing system is easy to use. Everybody who's adjusting to new software always, not everyone finds it easy to use, but I'm glad you do. And I don't know whether it's contributing to, smaller problems and fewer problems. It's hard to tell.
So lastly, I've found your sort of office one of the easiest offices to work with in state government. I think it's really well managed. Sort of my question from there is, with this bill, and this may be more of a question maybe for our analyst, but if we are going to put these additional sort of workload on your office, do you know if that'll be reflected in the fiscal statement or the fiscal impact statement that comes along with the bill, whether that is hiring somebody there to deal with this, or the cost of using sort of an outside auditing firm as you do for the clean election candidates? Do you know if that'll get worked into the?
Yes, I mean, there's three ways I'm going to try to be brief. I know you've had a long morning. There's basically three ways we could try to tackle what the sponsor wants to do. One of them is to hire an outside audit firm, which is what we do with the Maine Clean Election Act candidates, to do the audit of them, because we can't really do a real audit. That takes real specialized knowledge. So the fiscal estimate that you'll see with regard to this bill, and that was offered by us with regard to the bill from 2 years ago, covers the scenario of what would it cost us to hire outside auditors? And I'm not. I'll look at how we went about doing that calculation 2 years ago. The other way to tackle it would be to hire additional people. That's not going to be that's always an option if you want to hire. We have 6 employees. If you wanted to give us a 7th employee, or change the civil service classification of one of our current employees, we could always do that at a cost. But that cost would not be reflected in the fiscal estimate that we provide. The third way to do it, which I venture a description of in the 3rd page of my testimony at the very end of it, is could we do sort of an audit light type thing with our existing staff at no additional cost to the state? I know that might sound attractive to some, but what I spell out, we would just urge the committee and the legislature to take seriously what I put down in the last section there, which is that we could request bank statements and sort of compare bank statements to what people, traditionally finance candidates and PACs, report in their campaign finance reports. But and we could do that after the general election in theory, but it would really divert all available staff time from some really other highly valuable projects that would benefit the public. So we hesitate to go down that path, and we'd encourage you to take that seriously as a downside of it if that were the way you wanted to do it.
Thank you, Mr. Wayne. It's always a pleasure serving or working with your office.
Thank you very much. I appreciate that feedback.
Great. Any other questions? from committee members this time? Seeing none, thank you, Director Wayne.
Thank you.
Great, thanks. And so that concludes the testimony from everybody who signed up. We have nobody else in the waiting room. So with that, I'll close the public hearing on LD 413. So the public hearing's closed. We'll schedule a work session at some point in the future. So I believe that concludes our work for the day. I don't know if I'm mistaken on that, Janet or Karen. I think we're good to go. Okay, great. Check with both of the bosses. So, all right, with that, we'll be done. Thanks everybody for your work today, and we'll be back on, we're coming back on Monday, it looks like, with some public hearings, so at 10 a.m. So enjoy the weekend. Thanks everyone.
Have a good weekend, everyone.